All right, I restarted it. Can you hear me okay?
Yeah, I can hear you now.
Okay. All right, good. No problem. Let me just adjust the screen again. 1 second. Yeah, always gotta have backups. This technology never is perfect. 1 second. Okay. Can you sit back just a little bit further from the computer? Okay, great. That's great. All right. I just couldn't get enough of you in the screen. Actually, no, it's not sitting back. Can you tilt the screen a little bit so you're higher up on the screen? Okay, great. That's enough. That's good. Okay, perfect. All right, great. Okay, let me get it started again.
Okay.
Okay. So what are some of the common release conditions that people are subject to when they're arrested and then released from jail?
Well, typically here in Alachua County, standard condition for someone on a first-time DUI is typically that they're to possess or consume no alcohol or illegal drugs. They're not to drive without a valid driver's license, and that's really the two major conditions.
Wait, so what if someone's like 40 years old? They're not allowed to drink alcohol at all?
That is a condition of the release order almost always.
Huh.
The issue of whether or not you're going to get caught is a whole other matter. But
Wow. Okay, I didn't know that. So someone even that's way over normal age, they're not even really supposed to go out and drink even if they don't drive, right?
that's the intent of the order. Now, how someone's going to get caught doing that is a whole other matter because there's no one actually supervising you. But I would imagine the way someone would most often get caught violating that order is if they got arrested for some other alcohol-related offense, such as an open container or another DUI, God forbid.
Okay. And then you said, another common release condition is you can't drive without a valid license. So do you have people that come to you that lose their license because of the DUI arrest and they ignore that and just drive anyway?
Yes, it happens all the time. Alachua County doesn't have the greatest public transit system. It's not like New York City where you can, hop on the subway or get a cab at every corner. And a lot of people just feel that they have to drive to get to work or to school, and they're going to do what they need to do. And unfortunately, that can make your case a little more difficult to deal with if you get caught doing that.
Yeah. What's the consequence if you drive under a suspended license for reason of DUI?
Well, that's a good question. Under a DUI and a first-time DUI, unless there's some sort of extenuating circumstances, you're not going to get sentenced to any jail time. The night you spend in jail for your arrest is going to really be the only jail time you're going to do. Now, driving on a DUI suspended license is a whole other matter. You get caught doing that, and you're looking at anywhere from 10 to 30 days in jail, depending on which judge you're in front of.
When you say a DUI suspended license, is that before the conviction or after a conviction?
Either one, the courts treat them exactly the same. So if your DUI case is still pending and your license has been suspended by the DMV and you get caught, ultimately when that gets resolved, you're probably looking at jail time. Now, what that may do to your case is your DUI case might have been triable, but your driving on suspended license charge is not. In other words, you got caught speeding, you got pulled over, your license is suspended. It's pretty much open shut case. You may be forced to enter a plea to the DUI and then hopefully convince the state to drop the driving on suspended license charge and thereby not triggering any jail time. So you may have taken what was a good DUI case and turned it into, I got to plead to it now because I don't want to have to go to jail.
Okay. Let's talk more about the driver's license portion. So at the DMV hearing, which has to be done within the first 10 days, what issues do you argue, and do you have success in helping people, and what success is that? Do they just get their license back, or what happens?
Yeah. If you succeed in winning the formal review hearing, your client does get their full driver's license back at that point. And again, keep in mind, there's two separate things. This is just from the DMV. You could ultimately end up losing it down the road through the DUI in the court systems. But if you do win the formal review hearing, it's a pretty good indicator that you may end up winning at trial if it's based on the facts of the case.
Go ahead.
The issues at the formal review hearing are whether or not the officer had probable cause to believe that you were driving under the influence of alcohol in the state of Florida. And then if it's a breath sample, it's did you give a breath sample over the legal limit? And if you refused, it's did you refuse to give a breath sample, and did you refuse to do so after being read your implied consent laws, which talks about the suspension for not giving the breath sample.
Okay, gotcha. I mean, are the DMV hearings really tough to win, or do you have decent results there?
They're pretty tough to win. The main problem is, everyone knows the standard of a criminal case is to and beyond the exclusion of every reasonable doubt. At a formal review hearing, the standard is really a 51% standard. It's basically who does the hearing officer believe, and more often than not, unless you have a really good legal issue, sometimes you get a case that has a very glaring legal weakness, such as maybe you can tell that it was a bad stop. Therefore, the officer wouldn't have probable cause to believe you were driving under the influence. But more often than not, if the police officer does show up at the hearing, and let's say you were pulled over for speeding, and then you did field sobriety exercises, and then you either refused or gave a breath test, more than likely you're going to lose that hearing, and then you're going to have to go into this period of hard time where you can't drive whatsoever.
Is there a penalty for doing the DMV hearing? Will you be worse off if you lose than if you never did it?
No, it's treated if you never did it or if you lost, it's pretty much treated the same way. You either waived your right to the hearing, and so there's the suspension on your record, or if you lose, there's a suspension on your record. The downside, and this is a fairly recent law in Florida, is if you lose the formal review hearing, then the hard time kicks in where you can't drive whatsoever, either 30 days for a lawful breath sample or 90 days if you refuse to give a breath sample. But the new law allows you to waive your right to this formal review hearing if you wish, and if you do so, you're eligible for a business permit immediately, and you will never have to go through a period of time where you can't drive at all.
So the new law that affects the DMV hearing, it's essentially steering people not to fight and giving them a temporary ability to drive, and a penalty if they do go to the hearing and they lose.
In effect, that's exactly what the law has done. I think the DMV is trying to lighten their workload. And that's important why you need to come in and talk to an attorney almost immediately, so an attorney can evaluate your case and see, look, I do see some issues here. This officer pulled you over, it says that you were weaving and you didn't even cross the center line, or some other arguable stop, and there's multiple other issues. That case, you might tell the person, hey, look, let's not waive our right. Let's go ahead and have this hearing, because there's a high likelihood that you might get your full license back, and then you won't have this suspension from the DMV on your record. And you can also use that as basically a deposition to get the police officer under oath ahead of time and get their testimony. But if someone's been pulled over for going 75 in a 45-mile-an-hour zone, they do field sobriety exercises, it doesn't seem like they did well, they blow a point, blow twice the legal limit, that person might be better off waiving their right to formal review hearing.
All right, so if you waive the DMV hearing, the good thing that you'll get is you'll be able to drive at least to and from work for the next 30 days. You won't have a hard suspension. But the downside is that you'll still incur the DMV suspension penalty no matter what happens with your court case, right?
Yes. Yeah, the two things are always totally separate. They're not interdependent at all. But if you waive your right to formal review hearing during the pendency of the suspension from the DMV, you will be eligible for a hardship permit. I mean, you can drive to and from work, church, school, anything necessary to maintain your livelihood, and any on-the-job driving that you need to do. But if you elect to challenge this suspension at the formal review hearing and then you lose, if it's for an unlawful breath sample, you're going to have 30 days where you cannot drive whatsoever until you're going to be eligible for a permit. Or if it's a refusal, you have to go 90 days of driving whatsoever. So, some people need to make a cost-benefit analysis on which way they want to go. Right. And the first thing to do is to consult an attorney to see, do I have some good issues here or do I not?
Just in regards to the DMV hearing, what would happen if a person thought, oh, I'll just go represent myself at that hearing? Is it just a horrible idea that just there's no way they're going to win, or what?
Yeah, if someone wants to go that route, I would tell them just to not even elect it. Just don't even bother showing up, because you won't know what to argue, and the police officer is going to be able to just give their testimony, and I'm sure you'd lose at that point.
Okay. What for people that think maybe they'll just try to use a public defender, wouldn't the public defender not even be able to help them at this hearing because it's not criminal, it's administrative?
That's exactly correct. The public defender's office cannot, pursuant to their rules, do anything about these formal review hearings. And I have had some people that don't do it very often where they don't really think they have enough money to hire me for the entire case. But, for a smaller fee, I'll go represent them at the formal review hearing. So I don't think that's ideal, but, I do it sometimes.
Okay. All right. Oh, I don't know if we cover this. So just for a couple scenarios, what are the specifically the DMV penalties on the loss of license? You know, for a first-time DUI that has no special conditions or aggravations versus one that does versus the second. You know, what's the typical suspension?
Well, the DMV suspensions are really only on a first-time DUI. If you refuse to give a breath sample, you're looking at a suspension of a year. If it's a second refusal, you're looking at a suspension of 18 months. And then anything beyond that, if it's a third, fourth, or fifth, and it's a refusal, you're still looking at 18 months. But no matter how many DUIs it is, if you give a breath sample and it's over the legal limit, it is a 6-month suspension. So the only one that's really enhanced is if you refuse.
But what about if you have, you know, a high blood alcohol level, or if you get into an accident, or, you know, if you have kids in the car? Does that change the length of your suspension through DMV?
It doesn't change anything on the DMV side of it. Now, it does change how it's treated in the criminal court.
Okay. I just want to make that distinction.
Yeah, the DMV issue is really only, did you give an unlawful breath sample, or did you refuse to give a breath sample? If you gave an unlawful breath sample, your license will be suspended for 6 months. If you refuse, it will be either for a year if it's the first time, or 18 for a second or any subsequent refusals. That's the DMV's role in it.
And just to clarify, when you talk about the breath sample, do the police use preliminary little breath test devices at the roadside, or this is only at the station where they do the big machine they test you?
No, here they only do the big machines at the station.
Okay, so there's no confusion about that. Gotcha. And then, are blood tests used, or is it just about always breath?
Almost always breath. Occasionally, if the driver has been injured and taken to the hospital instead of taken to the jail, they may ask for a blood sample. Or if there actually is severe injury to someone, like loss of life or limb, they can force a blood draw in that case.
And if you try to refuse a blood draw, is it the same kind of penalties as a breath refusal?
It is the exact same penalties.
Okay. And then in terms of breath test refusals, do you have cases where the client comes and says, you know, I didn't refuse, I was hyperventilating, or I didn't understand, or, you know, a myriad of reasons, but yet they still were marked as refused?
Yes, that happens probably more often than you'd think. You know, and sometimes it's hard to tell whether your client was actually trying to fool the breath test machine, or if they actually really did have some medical issues. Unfortunately, at least again, we're talking about the DMV suspensions. These hearing officers are, you know, they're not lawyers, they're not judges. And if it comes down to the word of a police officer versus saying, no, this person wasn't trying to blow, I could tell they weren't trying to blow, or versus the defendant saying, well, I was really trying to blow, more often than not, it's not going to go in your favor.
Are you allowed to introduce evidence at the DMV hearing, or is that only for the court hearing?
No, you can introduce evidence. Like in your example, like if someone has asthma or something like that, you could bring in, you know, the prescription for their inhaler, or show they have an inhaler. You could ask the police officer questions about whether, when you arrested this person, did you find the inhaler on them? You know, so you can try those, but more often than not, like I said, it being a 51% standard, the DMV is typically going to rule against you.
Okay. All right. All right, so we talked about DMV having a 10-day fuse, essentially, since you've been arrested. What about the criminal court case part? What's the first event that'll happen, and how long before you have to go into court for the first time?
Well, your DUI citation is actually a charging document. So once you get arrested for DUI, you have been, in fact, charged with the crime. So that starts things moving a little quicker. You'll have an arraignment date that is usually about 3 to 4 weeks out from your arrest date. And so that arraignment is your first court appearance. The only options you really have at arraignment are to enter a plea of guilty or no contest and get your case over with, or you enter a plea of not guilty and you're given another court date. So really only one of two things happen. Now, if you hire an attorney, they're going to file a written plea of not guilty, which is going to waive the client's and my appearance at that court date, and then just set them down for the next stage.
Okay. And how? All right. So it's a charging document, your arrest paperwork. Again, how long before your first court date where you have to make a plea or do something?
Well, that first arraignment court date is going to be about 3 to 4 weeks out from the arrest date. And then after that court date, they're going to put you on what's called a pretrial conference docket, which, you know, in front of each judge's division, that meets once a month, and the cases kind of stay on these pretrial conference dockets month to month until they're either resolved through being dropped, or entering a plea, or going to trial.
Okay. out of the cases that you work on, what percentage seem to go to trial versus settle beforehand or plea out beforehand?
I would say probably about 10 to 15% actually go to trial. More often than not, if there are issues in the case, you can convince the state attorney's office to look at the problem. One of the big things that they do now is there's a diversionary program that only applies to people who, you asked about this 40-year-old person that, first time they've ever been in trouble. As long as they don't have a bad traffic record, and there's a number of factors that would allow them to be in this program, the state attorney's office might offer them a DUI deferred prosecution. And that's basically a contract that is signed between state attorney's office, myself, and my client. And the person agrees to stay out of trouble for 18 months. They basically do everything they would have done if they were placed on DUI probation. But if they complete all these things and don't commit any new law violations, at the end of that 18 months, they're then allowed to plead to an amended charge of reckless driving. That way they don't have the DUI conviction on their record.
Okay. All right, so yeah, we straight into diversion programs. But okay, so there is a diversion program for a first-time DUI, and what's the circumstances that you need to qualify for it?
Well, it has to be a first-time DUI. You can't have any other criminal history. You cannot have had more than one speeding ticket in the last year and no more than 5 in your lifetime. There cannot have been an accident in this particular case. There can't have been a child in the car in this particular case. There can't have been any drugs associated with this arrest. And they're pretty hard and fast rules. The one about having no prior history is the state attorney has kind of taken a little bit of a case-by-case basis on that. If someone had something very minor, 4 or 5 years ago, like a worthless check on their record, the state attorney might still agree to accept you in. But it's basically an application process. I have to recognize that my client might qualify. You take it to the assistant state attorney. They then decide if they do think you qualify, and then pass you on to the actual state attorney, who then reviews, your case and your history, and then decides whether or not he's going to let you into this program, because he's the one that actually monitors the program.
Okay. So when looking at diversion programs, do you get calls from people that say, oh, yeah, I had a DUI years ago, and I didn't think it was a big deal. I just pled guilty to it. And now they're in trouble because they can't qualify for the diversion program?
Correct. They're not going to qualify for that program. But then you start evaluating the case and see what's been brought to you. I always tell people that, the case that I can deal with is the case that you brought me. If you were weaving all over the road, speeding 30 miles an hour over the speed limit, you blow 2 or 3 times the legal limit, that case, unless there's some sort of error in the breath test machine or something to that effect that lets me litigate it, that case is going to be treated a little bit different than the person who gets pulled over for maybe, kind of not stopping on the stop line, and they don't do field sobriety exercises, and they don't give a breath sample. And that person hasn't given the state very much evidence against them in terms of being impaired. Whereas the first person I mentioned, there's a lot of evidence of impairment.
Gotcha. Okay. Do you have people that come to you and say, well, it's my first time being charged. It's no big deal. Maybe I'll just, get it over with and plead guilty. Is that a bad idea, and why?
Well, it's probably a bad idea in most cases, because you just never know, unless you have an attorney look at your case, as to whether or not there might have been something that was done wrong. If you're just going to go ahead and plead the DUI, you're going to have this DUI on your record. It's going to be on your criminal record and your traffic record for the rest of your life. You might as well hire an attorney to go through the case with a fine-tooth comb to determine, what, if any, motions need to be filed, and hopefully see if we can't take a shot at having you not have a DUI conviction on your record. Because ultimately, when a person comes into my office, the most important thing is to try to help them, no matter how we end up doing it, avoid a DUI conviction on their record. Because a DUI conviction is just that. It is a conviction, meaning that you cannot get it expunged off your record. It's going to be there for the rest of your life. Now, if we get you to plead to a reckless, as I mentioned, after this DUI deferred program, or if the case itself is something where I can negotiate a plea down to a reckless, you can then get a withhold of adjudication, which is not a conviction on your record. And then when you get everything done, you can get that expunged off your record. So really the main thing is to try to avoid the DUI conviction by all means necessary.
Okay. All right, and what do you find that people have misconceptions about in regards to their DUI arrest? What are they telling you that's not right, that you have to correct them on, that's common?
Well, I think a lot of people come in with the attitude that just because they think something happened one way and the police officer says that it happened another way, that their testimony is going to be giving more weight than the police officers. Typically, if someone says something happened one way and the police report says something different, I like to know that maybe there was another person in the car that can verify your client's story. Because when you're dealing with police officers as the witnesses in the case, typically a jury will give them much more credibility than they will the defendant who's in the trial.
Oh, okay, all right. I mean, how often is this circumstance that the police report and what the police say is radically different from what you experienced?
Well, it does happen a lot. One of the main things is the person who comes in here sometimes may or may not have the best recollection of what happened that night. And they may think that they did things better than they did, or they're not really sure how they did field sobriety exercises, for example. And the police report is written down in a way to make it seem as bad as the officer can possibly make it seem. And then what happens is typically there will be a videotape that we will get to watch. We don't get it until about 3 to 4 weeks into the process. But that videotape then sort of becomes the defining, okay, you said this happened, the cop said this happened, here's the video, what actually happened. And that's typically the best evidence.
Okay, all right, gotcha. Any other misconceptions people have about the DUI process that are common?
No, not really. I think enough people have heard about DUIs, had friends that have had DUIs. They know what to expect to a certain extent. I think a lot of them don't really understand the licensing issues, the issues about the timing of when things need to be taken care of, the whole issue about not having a driver's license whatsoever for a period of time. If you lose a formal review hearing, people just don't understand why they can't have a license, or I can't do that. I have to have a license. Well, luckily now we do have this option to waive the formal review hearing, and then you can avoid having to go without driving at all.
Gotcha. Okay. Do you feel like the public has misconceptions about attorneys, and specifically, in relation to DUI? Do you find that people seem to think about you in a way that's not accurate for some reason or another?
I don't really think so. I think attorneys in general sometimes get a bad rap, but then typically everyone hates attorneys, but they tend to like their own attorney if you do a good job for them. I think what happens is people end up they get sued over debts, or they get in a divorce, and they end up getting in the system, and they think that it's the lawyer's fault. Where all that I can do as a criminal defense attorney is deal with the case that you brought me. You come to me, I'm going to treat you with respect. I'm going to do everything that I can to minimize the damages it's going to have on your life.
Okay. Yeah, last question for now. Any particular, story of a past case that you think is really instructive or interesting or crazy that you want to talk about?
No, we talk about this, but I don't really like talking about my cases, quite honestly. I don't feel comfortable doing that.
Oh, no
I hate to have someone watch one of these videos and go, "Oh, hey, that's my case."
Oh, that's true. Yeah, that's true. Okay, well, that's good. You hold everything in total confidence. So.
Exactly.
All right. Let me get the broadcast stopped, and I'm going to call you offline. Okay.
Okay. Thanks, Rich.